Thank you, Justin, for that introduction. Thank you, Kevin, for everything that went into today's event. Thank you to the Institute for the Study of the American Constitutional Heritage. It's actually my third time in Norman, which is a real treat for me, but the first since moving to UT. I have to say, I was really worried that you guys were going to be really hostile this time around, but I guess you just don't care about UT football right now. I wonder why. I actually should confess that I grew up a Michigan fan, so I'm actually really indebted to all of you guys. Thank you for Ohio State. And so in honor of that, I actually wore the closest thing I have to crimson and cream for the talk today. So if nothing else, hopefully that gets me out of here without too many tomatoes. When Kevin reached out to me about giving the Constitution Day lecture, I said, oh my gosh, that sounds like so much fun. Whatever should we talk about? I mean, there's nothing interesting going on in constitutional law right now. My favorite topic for a Constitution Day lecture actually it has a pretty straightforward title. It's, is Constitution Day unconstitutional? By the way, the short answer is yes. So that lecture ends up being pretty short. Kevin said, you might actually want to have to, talk for more than 5 minutes. So we took a look at what was going on in the headlines and what a lot of folks have been talking about. And we thought it would be a good time to reflect a bit more generally on what is a constitutional crisis and are we in one? And just to give away the ending, in case you got to sneak out beforehand, the ice dragon burns down the wall. Oh, wait, sorry. Too soon. To give away the ending, the short answers are it's complicated and not yet. So let me take a few minutes to unpack each of those points, tell you where I come from, and hopefully we'll have some time at the end for Q&A. So what is a constitutional crisis? Well, the definition I want to offer today is a bit wordy, but I hope clearly conveys my point. So here we go. A constitutional crisis arises whenever one of the institutions responsible for preserving the checks and balances within our constitutional system loses the ability, whether at its own hand or that of others, to do so. I told you it was wordy. This may seem like a narrow definition. I mean, by that logic, there are lots of things that sound like crises and feel like crises and are not crises. But let me try to use a couple of case studies to illustrate why I think this narrow definition is, in fact, the proper way to think about the issue, and perhaps more importantly, why I think we should keep clear the difference between a constitutional crisis, which is a whole big problem, and a political crisis, which may be actually more important in the moment we live in, but perhaps less important in the long run of our constitutional system. All right, so 4 case studies. Case study number 1, the election of 1800. And here, please forget everything you learned from Hamilton the musical. A little bit of artistic license in that song. Okay, so if you know your American history, right, this was a battle between the Federalists and the so-called Democratic Republicans, right? John Adams seeking a second term versus Thomas Jefferson, and to a lesser extent, Aaron Burr. Of course, right, what happens is there's a tie, but the tie is between Jefferson and Burr because under the Constitution as enacted, electors vote for 2 people without specifying which one is supposed to be the president and which one's supposed to be the vice president. And everyone was so nervous that the election was going to be close that it turns out that all of the Democratic Republican electors vote for both Jefferson and Burr. All right, so 2 interesting things happen, right? First, this is my favorite part of this story, Thomas Jefferson effectively counts himself into the presidency. So how does that happen? We have to do a little bit of math. I know you guys, there was no math, like on the flyer, it said no math. We have to do a little bit of math. So in the election of 1800, the threshold for a majority was 70 electoral votes, right? So 69, you wouldn't have a majority. If you had 69 or fewer, if no one had 70 or more, then the election went to the House to choose among the top 5, right, electoral vote getters. If there was a majority and there was a tie, the founders contemplated the possibility, then the House would choose among the top 2 vote getters. Well, turns out Georgia, thank you Georgia, screwed up their electoral votes, right? They were formatted incorrectly. And Georgia had 4 electoral votes. So if you didn't count Georgia's 4 electoral votes, Jefferson and Burr would have 69. And then the House would break the tie between the top 5 candidates, which included Jefferson, Burr, and 3 Federalists. The Federalist lame duck House would break the tie, right? So you had a real prospect for a crisis. Not to worry, the presiding officer of the Senate is in charge of counting electoral votes when they're opened, And in this case, the presiding officer opened George's electoral votes and decreed that they were correct and proper and there was no problem whatsoever. Who is the presiding officer of the Senate? Thomas Jefferson, right? All right, so problem number one, right? Thomas Jefferson counts himself, right, into the two-way tie by decreeing no problem with George's electoral ballots. Problem number two, deadlock, right? So the election goes to the House tries to break the tie. The first 35 ballots, right, there is no clear victor. Everyone starts to get freaked out. It's February 17th, inauguration is supposed to be March 4th. What happens if we get to March 4th and there is no confirmed president? There's actually some debate about this. There's a statute called the Presidential Succession Act of 1792, and there was an argument under the statute that if you got to March 4th with no president and with a new Congress and with no vice president, the presidency would fall upon the Secretary of State. Anyone know who the Secretary of State was? John Marshall, who was a Federalist. Okay, so we have real trouble. But on the 36th ballot, right, famously, Delaware breaks the tie, votes for Jefferson, everyone goes home, Burr goes to kill Hamilton. Well, if you listen to the musical, that's the order of events. It's not quite that easy. Okay, here's the question. Was that a constitutional crisis? I want to suggest, perhaps counterintuitively, that the answer is no. Right, that in fact the system was working exactly the way it was supposed to, even if it was this fakakta cockamamie scheme to vote for the top two people as opposed to a president and a vice president, right? But look how close we were, right? If we had gotten to March 4th with no resolution in the House, right, then yes, I think we would have had a constitutional crisis because the system would have broken down, right? Because the presidency would have fallen to someone no one voted for, right, from a party that had just gotten trounced on the hustings, and I think you would have seen perhaps even violence in response. We avoided it. We dodged that bullet. Okay, case study number two. Let me jump over the one thing I think everyone will agree was a constitutional crisis, the Civil War, and let's fast forward to Reconstruction. So Reconstruction, right? Andrew Johnson succeeds President Lincoln upon Lincoln's assassination, and then the radical Republicans win huge majorities, right, in both the House and the Senate in the 1866 midterms. So now we have a Democratic president, who is not super into the harshness, right, of radical Reconstruction, and we have veto-proof supermajorities of radical Republicans in both the House and the Senate. The result is a bunch of, I think, really positive things, like the Civil Rights Act of 1866, the 14th Amendment, and so on, but also some less positive things, like the Military Reconstruction Act, right, which turned the South into a series of military districts to be governed by the Army, not by civil authority. The Tenure of Office Act, right, through which Congress tries to prevent President Johnson from firing any of his cabinet secretaries. So there are actually two different episodes I want to highlight within Reconstruction. The first episode is the litigation over the Military Reconstruction Act. So this begins shortly after the act is passed with a lawsuit by the state of Mississippi. And Mississippi sues President Johnson directly in the Supreme Court, invoking the original jurisdiction of the Supreme Court. And there's this remarkable moment. Keep in mind, Andrew Johnson vetoed the Military Reconstruction Act, thought they were unconstitutional, was vehemently opposed to both their policy and their enforcement, and nevertheless walks into the Supreme Court, well, he sends his Attorney General, but sends his Attorney General to argue that the Supreme Court has no power to issue an injunction against him, right? Not because of the statute, but because he's the president and they're the Supreme Court. And the Supreme Court, which is all too happy to avoid what would have been a cataclysmic ruling one way or the other on the merits of the Military Reconstruction Act, obliges and issues this very terse opinion that the federal courts lack the power directly to enjoin the president. This case, by the way, Mississippi versus Johnson, being invoked by President Trump for why he can't be forced to unblock people on Twitter. So I guess things come full circle. But know what happened, right? President Johnson, in the midst of what could have been described a constitutional crisis, asserts the constitutional authority of the executive branch to defend against an action he completely opposes, right, and to protect the prerogative of the executive branch. To me, right, that's the structure working the way it's meant to, not actually a constitutional crisis. All right, fast forward to the Tenure of Office Act. The Tenure of Office Act is passed shortly thereafter. Again, President Johnson vetoes it on constitutional grounds. This time, right, Congress fires the gun, right? This time Congress says, aha, you have committed a high crime or misdemeanor, we can now impeach you. And so the House of Representatives votes out 11 articles of impeachment, although honestly it's just 11 different ways of saying he violated the Tenure of Office Act. Kind of funny, right? And the Senate tries Andrew Johnson and comes within one vote of removing him, right? The vote on 3 of the articles was 35-19. Had one more senator voted for removal, that would have been the 2/3 threshold required by the Constitution. Imagine if that had happened, right? Imagine if you had a president who was impeached purely for political reasons, based on a constitutional argument that was not well received at the time, and that the Supreme Court, in fact, will, about 40 years later, hold to be unconstitutional, right? Imagine if you had a purely partisan impeachment of a president based solely on political differences. I think that would have been a constitutional crisis. We escaped that one by the skin of our teeth, but escaped it, I think we did. And you could say the same for the one impeachment of a Supreme Court justice in American history, back in 1805, when the Democratic Republicans tried to impeach Federalist Justice Samuel Chase. And again, the conclusion was impeachment is not supposed to be for pure partisan political disagreement. That too was a close call. All right, so those are our first 2 case studies, right? The election of 1800, Reconstruction, moments where we came perilously close to what to me was the constitutional cliff, but were fortunate enough to not jump off. All right, fast forward to 1937. When we get to what to me is case study number 3, President Franklin Delano Roosevelt's court packing plan. All right, so a little background, right? FDR is elected with huge majorities in 1932, comes into office in 1933, has this massive wave of legislation. A lot of it is actually relatively novel from the perspective of the types of power it was claiming. And you have a pretty conservative Supreme Court led by 4 conservative justices who were known at the time as the Four Horsemen of the Apocalypse. This was, just to show you how college football is everywhere, this was not a biblical reference. This was a reference to the Notre Dame backfield of the 1920s. So even in 1925, right, college football was defining the national conversation. I think in Norman I can say that without getting in too much trouble. Okay, so FDR has a really bad year in the Supreme Court, and the bad year is 1935. The Supreme Court strikes down 3 of the major centerpieces of the New Deal program. The Supreme Court asserts various limits on presidential power that had not previously been recognized. And in at least a couple of cases, the court was actually unanimous. Forget the Four Horsemen. Even the more progressive justices were aligned against FDR. So FDR in 1936 runs as much against the Supreme Court as he runs against any Republican opponent, wins a landslide, is returned to Congress with huge majorities in both houses, and decides that the time has come. And so in early 1937, he launches what he styles as a completely benign effort to account for the rapidly aging federal judiciary. And what FDR says is, you know what? Our judges are old, and we need to help out the old judges. So for every judge who has reached the age of 70 or above, we're going to add another seat to that court, whatever court it might be, any court, anywhere in the country. What a coincidence. 6 of the 9 Supreme Court justices had reached the age of 70. And so the bill, if passed, would have expanded the size of the Supreme Court to 15 with 6 brand new FDR nominees. I'm sure that had nothing to do with it. And this is basically viewed, I think correctly, as a direct assault not just on the court of that time, but on the independence of the judiciary in general. Had FDR been successful in expanding the size of the Supreme Court, I think it would have seriously damaged the Supreme Court as an institution. More importantly, I think it would have set the precedent for any party, once it gained control of both houses of Congress and the presidency, to expand the Supreme Court to its own political benefit. The Supreme Court today would have 91 justices. That would be awkward. Instead, right, 2 things happened, and I think historians are split as to which was causal and which was sort of more of a byproduct, and indeed as to whether they were even related. The first thing that happens is FDR meets at least what was to him surprising resistance, right, and surprising backlash from members of his own party in the House and especially the Senate. Right, that for once the court as an institution appears more important than the politics of the moment. But then two, of course, perhaps more famously to students, is the switch in time, right, where on March 29, 1937, Justice Owen Roberts switches his vote, right, in the West Coast Hotel versus Parish minimum wage case, which is the harbinger of the fundamental shift in the court's approach to economic regulation, and basically portends the era of deference to legislatures that follows, and with it, basically, the upholding of almost all of the major New Deal programs. So, I think there are a couple ways to look at this episode. One, once again, we came perilously close to a constitutional cliff where the credibility and legitimacy of the Supreme Court would have been damaged, if not, indefinitely, at least for a long time. Two, we averted it because one or both of the institutions not necessarily pushed back, but at least found ways to abate the crisis, found ways to sort of tone things down. FDR then abandons the court packing plan. He says because he's become convinced it was unwise. In fact, it had become unnecessary. Okay, last and perhaps most recently, and this might be the one that's sort of most on everyone's minds, Watergate. Right, I think there are lots of reasons to compare Watergate to various things that are going on around us today. So let's start with the first sort of moment of real crisis, the Saturday Night Massacre. Right, so President Nixon wants to fire the special prosecutor investigating Watergate, Archibald Cox. Right, he orders his Attorney General Elliot Richardson to do it. Richardson says, no thank you, and resigns or is fired, depending upon your perspective. I go with resigns. Then he orders Richardson's deputy, Ruckelshaus, to do it. Ruckelshaus says no, he's out, right? And then Robert Bork, who was at the time the Solicitor General, and on the line of succession was the acting Attorney General with those two out, says he'll do it, right? Was the Saturday Night Massacre a constitutional crisis? I submit to you that the answer is no. Right, that under the regulations as they existed, the president had the unquestioned power to fire the special prosecutor. He had the unquestioned power to fire the attorney general for not firing the special prosecutor with political consequences. And I think this is one of the points that really comes through, right, that sometimes the appropriate response to what may seem like a constitutional crisis is in fact a political reaction, not a legal one. Right, that those kinds of measures are supposed to be understood to trigger a political reaction, and if the president has political support to do it, then we tend to think it's within his power. All right, so what happens next? Well, there's political blowback in response to the Saturday Night Massacre. Right, Congress really, I think, at that point starts to get very, how shall I say, ornery about the whole investigation. Congress really ratchets up its investigation. A new special prosecutor is appointed. Right? This time, one who there's a sort of deal made where Jaworski won't be fired, right? And where no one will be instructed to fire him. And what happens? Well, Congress and the new special prosecutor both subpoena the infamous tapes. Okay, so we have subpoenas for the tapes. The case goes to the Supreme Court, and the Supreme Court in July of 1974 rules that Nixon has to comply with the subpoenas. He has to turn over the tapes. Was that a constitutional crisis? I would say no. All right. What if Nixon ignored the Supreme Court? Aha, this is where now it sounds interesting, right? Well, the Supreme Court orders him to turn over subpoenas, to turn over these tapes, and he doesn't do it. That must be a constitutional crisis. Maybe. But one thing would have happened for sure. If Nixon had refused to turn over the tapes, he would have been impeached. Right? He would have been impeached, at least in part, for refusing to turn over the tapes. Instead, he turns over the tapes. The tapes end up inculpating him rather dramatically, and he resigns several weeks later on the eve of impeachment. Right? Is this an example of a constitutional crisis? I want to suggest that the answer is no. Right? That the institutions actually worked the way they were designed to under pressure. The president put pressure on the institutions by firing his subordinates to achieve a particular, if controversial, policy outcome. The political branches, the House and the Senate, pushed back. The courts pushed back, right? And it culminated in what was a constitutionally appropriate denouement. So in each of these moments of unquestioned political crisis, we came perilously close to a real constitutional crisis, closer than I think we often accept, right? One or two things changing in each of these stories, and I think we would have had much more serious of a matter in an episode. But something happened, for better or for worse, to prevent us from going over the precipice. Moreover, although individual actors and/or institutions may have overstepped their bounds in each of my examples and plenty of others, right, the Constitution's structure worked in each of these contexts, with the relevant constitutional mechanisms serving, perhaps more slowly than we might have liked, to avoid or at least abate the real crisis. Right? So I guess all of this is leading toward this conclusion that we actually have lots of political crises in this country, but we've been lucky, at least so far in our history, to experience relatively few constitutional crises. So I guess what all that suggests is that in those contexts, it was the Constitution itself that functioned, for better or for worse, again, to prevent a constitutional crisis. All right, so let's take these lessons, such as they are, and apply them to the present moment. The present moment. I always feel like I have to take a deep breath when we turn to the present moment. So for starters, it seems to me beyond dispute that the President of the United States has gone out of his way to attack each of the institutions that are designed to serve as a check on him, including the formal checks of the legislature and the courts, and the informal check provided by the media. I don't think that is a controversial statement, right? I think everyone would agree that, yes, the president attacks these institutions. But has he actually done anything? Is there anything beyond tweets to undermine the actual authority of those institutions to do their job and serve their function? Well, let's take them one at a time. So start with the legislature. So it seems to me there are three interesting flashpoints when it comes to the president's relationship with Congress. First, and perhaps least interesting, is his newfound obsession with getting rid of the filibuster. Right? Whatever you think of the filibuster, it is a creature of Senate rules. It is not part of the Constitution. You know, I think that it obviously causes a huge policy concern, no matter whether you're a Democrat or Republican, an independent, or a Martian. But as a constitutional matter, I just don't see people getting exercised about having or getting rid of the filibuster for ordinary legislation, especially if you accept, as I do, that the Senate has the power at any moment by a majority vote to get rid of the filibuster. A better example, I think, is the assertions of what has been called the non-privileged privilege. So there have been a series of witnesses, government employee witnesses, who in both well-noticed and much less interesting congressional hearings have invoked a new kind of executive privilege, where they're not even invoking privilege, they're invoking their right to not even assert executive privilege. This is a new thing, by the way. In other words, right, usually the way this is supposed to work is an executive branch witness goes to Congress, is asked a question he or she doesn't want to answer, asserts executive privilege, and then there's a fight about whether the privilege is validly asserted. That's the way the structure is supposed to work. What happens when you have this non-privileged privilege issue is you have invocations of something that sounds like executive privilege, but until and unless Congress forces the witness to formally assert executive privilege, he or she is off the hook. All right? This strikes me as not yet a constitutional problem, but note the role of Congress. Right? The executive branch is, in a way, thumbing its nose at the compulsory powers of Congress to compel testimony or evidence, but Congress hasn't reacted by asserting them. Right? To me, the problem arises if we get to a point where Congress pushes back and says, no, you must assert the privilege, and then things go off the rails. So again, right, we're sort of rolling down that mountain, but pretty slowly. Third, right, for all the talk, and I am one who does a lot of this talk, that Congress has been largely feckless over the last 8 months, consider the Jeff Sessions firing trial balloon. Right? So there's a lot of talk a couple weeks ago about the president's desire to fire Jeff Sessions. We learned, I think, late last week that the president, in fact, had an offer from Sessions to resign. And there was speculation that the president might do all kinds of shady things to put someone in the attorney generalship who might be much more willing to try to shut down the Russia investigation. Well, what got much less attention was a statement by Senator Charles Grassley, the chair of the Senate Judiciary Committee, that, quote, "We are too busy for any more confirmation hearings," unquote. asked to clarify, Senator Grassley said, there will not be another Attorney General confirmation hearing this year, period. Right? So that sounds like, okay, politics, whatever, people just, saying what they're going to say. That is the Republican chairman of the Senate Judiciary Committee telling the president that if he fires Sessions, he's not getting a successor. Right? That's actually a pretty powerful, I realize we're desperately looking for signs, right? But actually that's a pretty powerful one, right? The Congress is not actually wholly rolling over. The Congress is paying some attention to what's going on. The Congress is asserting at least a little bit of its institutional priorities and privileges. So with regard to the legislature, I think there's nothing really there yet. Maybe a better example is the courts. President Trump, not a big fan of the courts, or so his Twitter feed tells me. Of course, right, there's the whole Judge Curiel situation. There's his ongoing tweets about the travel ban. And let me just say, I think Neil Katyal, who's the lawyer for the state of Hawaii, has said this best. The president has basically become co-counsel to the challengers in the travel ban cases. Every time they need something, he helps them out. Right? The president's attacks on the courts, though, have been purely rhetorical. Right? He has done absolutely nothing to suggest non-compliance with these decisions. The government has responded to every single order in these cases in a manner that was procedurally appropriate, right? There was compliance all up and down. Even the grandparents, right? There was this whole stink about the grandparents and the guidance from the government that after the Supreme Court's June 26th ruling in the travel ban case, the government was still going to exclude grandparents, even though those are clearly, right, close family members. That's just a fight over interpretation, which the government then lost in court and then complied. Right? So to me, again, right, we have to separate the bark from the bite. The president talks a big game, but as I think we will often find with him, there's not much there. Okay, the more interesting moment for me when it comes to the courts is the pardon of former Maricopa County Sheriff Joe Arpaio. I was a law clerk after law school on the Ninth Circuit, the Federal Appeals Court for the West Coast, including Arizona. Joe Arpaio is a jobs program for lawyers. Especially civil rights lawyers. And so the president pardoned Sheriff Arpaio when the underlying offense was contempt of court, because Sheriff Arpaio had been disobeying court orders and continuing to profile what he believed to be Mexican nationals as part of his immigration enforcement policies. Of course, this sounds bad. This sounds like it's an attack on the courts. You have an executive officer, Sheriff Arpaio, who was disrespecting the courts, who was held in contempt for doing so, and the president lets him off the hook. And my response is, that's how the pardon power works. Right? There's actually a Supreme Court decision directly on point from 1925, written by Chief Justice, and we might add, former President William Howard Taft, that the pardon power extends to contempt of court. Right? The theory being that the pardon power is actually a check built into the Constitution for abuses by the courts. And if there's a concern, Taft literally says this in his opinion in Ex parte Grossman 92 years ago. He says if there's a real concern that the power is being used abusively or in a manner that's just designed to help your friends or patronage, then the remedy the Constitution provides is called impeachment. Right? So again, this is not a breakdown in the constitutional structure. It's just a politically objectionable, politically problematic development. Okay, so that's the courts. Of course, we'll see what happens with the travel ban cases going forward. Perhaps they'll be moot. Perhaps the president will reinvigorate the travel ban between now and October 10th. But more tweets are surely to come. And let me last say a bit about the media, because I actually think this is the area where if there's cause for concern, it might be the most grave. So there's been lots of problematic commentary and media access policies, right? The White House for a time had stopped allowing video recordings of the daily briefings. I loved the surreptitious video recording. That was hilarious. But, I mean, to be frank, there have been no actual efforts to go after the press, whether for libel, as the president has repeatedly promised he would, or for its role in leaks, which has long been a concern of the media, right? That the government might ramp up its ability to use prosecutorial tools, especially in national security cases, to go after reporters for ordinary news gathering. The only real news story that we have with regard to the media was last month when the Justice Department had this much ballyhooed press conference where Attorney General Sessions talks about how much tougher they're going to be on leaks and reporters, and we're going to revisit everything. It didn't actually change any policy. right? Nothing actually changed as a result of that press conference. And so what we have, right, is again, the rhetoric outstripping the reality, where it sounds like things are actually much worse than they are, and where the political crisis, right, is being confused for a constitutional one. Now, let me sort of underscore this last point, right? All of this could change, and in a hurry, if, for example, the president starts defying judicial decisions or refusing to comply with subpoenas or prosecuting reporters or finding ways to subvert Congress. My point this afternoon is that we're just not there yet. Now, that there's no constitutional crisis does not mean that we're not in the middle of a political crisis. And I do think we are in the midst of a sustained and serious crisis of politics in this country. But that crisis predates this president by a fair amount of time, and it will continue after he is out of office, whenever that may be. And whether it's cause or effect, it seems to me impossible to sever the link between the political crisis and the polarization of Congress, to the point where things that would never have been viewed as partisan as recently as a decade ago are cast today wholly in partisan terms. I am looking at you, Russia, right? The real question, it seems to me then, even on Constitution Day, is whether this political crisis is actually going to increase the likelihood of a constitutional crisis, at least insofar as Congress in particular is unable or unwilling to use the authority it clearly has to respond to an envelope-pushing executive branch. And here again, I would hearken back to the non-privileged privilege example, right? If Congress is really going to allow executive branch witnesses to come purport to testify, not really invoke privilege, and not answer questions, I think eventually, if that repeats in perpetuity, you could get to a constitutional crisis. We're just not there yet. So in this regard, I'm reminded of an oft-told story about a freshman Democrat in the House. And I actually did some research on this. It actually likely originated as a quote by Sir Winston Churchill, but the West Wing picked it up and turned it into a quote by a House member. And so like today, every reference is to the House, and you can't find any pre-West Wing references, right, to it being like an American construct. But bear with me. So the way the West Wing tells the story, although it really sounds like Churchill, the Democratic House member is walking around the Hill with a senior member of his party. This guy's a freshman. And he says, "Where are the Republicans? I want to meet the enemy." And the senior member pats the freshman on the shoulder and says, "No, no, no. The Republicans aren't the enemy. They're the opposition. The Senate. Now that's the enemy." Does anyone think like that anymore? Right? I mean, this was, whether it's apocryphal or not, how the separation of powers used to function. The House and the Senate were almost separate branches, right? And instead, we don't think or talk like that today. Ours is increasingly a system favoring the separation of parties rather than the separation of powers. And when you have divided government in Washington, that tends to work out okay, at least in the sense that nothing happens. But when you have one-party rule, you have a real concern for breakdown, right, even in the constitutional checks. And so I guess my sort of bottom line in closing, right, is that we've been lucky thus far that this trend hasn't caused, or at least hasn't prevented, Congress from stopping a real constitutional crisis. But given the world we live in, it may just be a matter of time, or tweets, before our luck runs out. Thank you very much.